Welcome to Beasley's Managing Risk Together. In this video series, we look at important risk management issues for design professionals and think about ways to better manage that risk. I'm your host, Colleen Palmer, and I look after the risk management services for Beasley's U.S. A&E policyholders. Today, we want to talk about dispute resolution, and this is another area of your contract that should be addressed. And we typically recommend that the parties agree to submit all disputes to non-binding mediation prior to litigation, to the extent the dispute is not resolved in mediation. And we like mediation because it's a voluntary, non-binding, confidential process that we have found if parties enter into good faith and they really go with the intention that they want to resolve a dispute, mediation can be very, very effective. And many disputes are ultimately resolved in a mediation procedure. The kind of nuts and bolts of mediation, we want to talk about a little bit. Mediation is guided by a mediator that is selected by the parties, and the mediator assists the parties come to a resolution of the claim. And we can talk later about what makes a good mediator and things you could think about when selecting a mediator. But for today's session, we want to think about the differences between mediation, arbitration, and litigation. So we have mediation. We've agreed we're going to submit disputes to non-binding mediation. If the dispute is not resolved by that process, then we have to make a decision. Do we want to select arbitration or do we want to litigate disputes? Both are binding dispute resolution mechanisms in that at the end of the proceeding, there is going to be a decision made. We, generally speaking, recommend litigation over arbitration, and here are some of the reasons why we recommend litigation. Arbitration is a procedure that is guided and decided by either one arbitrator or a panel of arbitrators that are selected by the parties. Sometimes your contract will say that your client has the sole right to select the arbitrator or arbitrators, and certainly we want you to have a role and an opportunity to participate in that selection. It should not just be the client. But arbitration itself has some drawbacks, and kind of primarily the fact that arbitration is binding and essentially non-appealable. So when that decision is made, you don't have the same rights of appeal that you would ordinarily have in litigation. Also, with arbitration, the rules of civil procedure and discovery that you would ordinarily have in litigation do not necessarily have to apply. The other kind of elephant in the room with arbitration is that sometimes arbitration results seem arbitrary. And despite good arguments that you may have that you are not liable, arbitrators may say, well, the claim's for $1 million or $2 million. Let's just split it down the middle. And design professional, you'll agree to be responsible for half of that. And plaintiff owner, you'll agree that you'll let go half of those damages. So sometimes we see this arbitrariness that disfavors design professionals. So with litigation, on the other hand, you do have rights of appeal. You do have the rules of civil procedure that apply. You do have the discovery process that you can use to gather information and help your case. So for all of those reasons, we generally speaking do like to see your dispute resolution provision require all disputes be submitted to non-binding mediation as a condition precedent to litigation. If you absolutely have to have arbitration as your binding dispute mechanism, and sometimes owners or clients just absolutely demand that, then we do recommend that you add some language saying that the parties agree that they will follow the rules of civil procedure and allow for a certain amount of discovery that you'll negotiate about what that will be. And we recommend that you limit the threshold of claims that are submitted to arbitration. So what I mean by that is that you'll say, well, we'll agree that all claims in controversy less than $100,000 will be arbitrated, but anything in excess of that $100,000 we'll agree, client, we want all of those additional claims to be submitted to litigation. So that's a nice compromise that you'll agree that for claims that are less than a certain dollar threshold, you'll arbitrate, but anything above that, more potentially expensive claims, that'll be litigated. And then, of course, you'll have those protections that are afforded to you in litigation. So that's all we have time for today. Thank you so much for joining me. I'm Colleen Palmer, and I'll see you next time on Managing Risk Together.